You have to bow out early.
Okay,
All right, you are live.
and we will call this meeting of the Akron Civil Rights Commission to order. Our first order of business on our agenda is I will consider a motion to suspend the rules regarding in-person attendance, voting, and public comment. So if I can have that motion.
So moved, Nancy.
And is there a second?
Second, Gina K.
Fabulous. All in favor say aye.
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 Any opposed? That motion carries. And next we have approval of minutes. I saw that we did get November minutes. I wasn't sure if we got, have we received October minutes?
Yes, I CC'd everyone on the email that I sent over with all of the minutes since.
Okay. Let me just find my, So that being the case, if somebody is prepared to move those approval of those minutes.
So
Or-
moved.
For both, let me just clarify, is that motion for both October and November?
That's correct.
And is there a second?
I second.
All right, any discussion? All in favor say aye.
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 And is there any discussion or, I'm sorry, is there any opposed? So the minutes are approved. And let me come back to my agenda. We have old business. We have a couple of complaints that we have not yet concluded. So the first of those is from 19 ACRC 00013, and that was with Commissioner Pitt. Is there a report on that complaint?
There is not. It is ongoing. And I will,
Ongoing.
I will gladly admit this month that my momentum is slow and I apologize, but I am making headway, and it's just all the implications of COVID, between work and home life and kids at home, it is just going slower than I would like, but it kind of is what it is at this point. But we are making progress and just finding dates to arrange the last interviews.
Okay, so in progress investigation. Can you remind me? So I know that was 2019. John, is there anything that gets, I'm just checking in on whether there's any procedural triggers that we have to worry about with regard to an investigation that goes on. If we should formally waive some any deadlines or anything.
Well, the deadline that I'm aware of is that the complaint's required to be filed within a year of the alleged discriminatory conduct. But I do not believe that either the ordinance or the rule has a timeline for how quickly the case has to be resolved.
Okay, I just want to make sure that if there's something that we,
Yeah.
Can or should do to make sure this doesn't have some repercussion. And then the other ongoing complaint we had is we had merged 20 ACRC 03 and 04. Is there a report on that complaint? That was with Commissioner Mobley.
I do have a report, and
Okay.
I could use some advice from the commission. So I've conducted the initial investigation and spoke with the complainant and the respondent and a couple of other participants. And it's so multifaceted, I'm not really sure how to move forward. The complainant, if you all can recall, there were several boxes checked in areas of discrimination: age, familial status, race, gender identification. There were several different areas. So when I spoke with her, she mentioned that she was a contracted, her employer was contracted to clean a building. And in cleaning that building, she worked with other employees that were contracted by other companies. The response is Medjed Aircraft. Hi, Esther. And they contracted an additional security company. So we're 3 out in terms of companies. The security personnel that was contracted through Medjed are the people who allegedly said discriminatory things and created the hostile work environment, according to the complainant. In understanding what happened and understanding why the complainant was terminated from her job, there were things, and I don't know how much detail I'm supposed to get into, but the reasons why she was asked not to return are things that she admittedly did. There were 3 things in particular. There were masks at the security desk that were used for the public who might not have had a mask while entering the building. She would take a mask each day when she came to work. And it's not that she wasn't told that she couldn't, but it was kind of an unspoken rule that you weren't supposed to take those. There was a free vending machine with snacks, and she would use the vending machine. And again, it was free and not spoken that she couldn't, but a professional courtesy kind of thing that you shouldn't as a contractor. And then there was an incident where she, for superstitious purposes, did not want a particular numbered security badge and would have altercations with the security as they gave her her badge on a nightly basis. So her termination was valid based on the HR rules. However, and the discrimination did not come from anyone who she was in direct contact with, nor the respondent. So I'm not sure how to move forward with that.
So my understanding of the way this works at this point on the rules, right, is that you make a report, and I think, I mean, the finding that we're talking about is whether to find that there's reasonable cause that discrimination occurred, and in violation of the statute, right, of our ordinance. And it sounds like it's a little unclear right, for you, and then maybe we should see if we among us can clarify whether what happened counts. On 2 bases, right? One is that it's a contractor who's making the complaint and a contractor whose conduct comprises the discrimination, I think. And then sort of whether terminating her on the basis of violating unspoken rules can be the basis of a discrimination claim. Am I kind of getting that right?
You are. I'd like to address the first one. It's actually pretty well settled idea that employers are responsible for anything that happens in their workplace, whether it's the the copy machine repairman or, the postal person or the UPS person. I think we don't have to get too bogged down in the issue. Now, whether there needs to be an amendment to add an additional respondent, because, there could be joint liability on the part of the contracting company. Was that Medjit contracted with the security firm?
Mhm.
It could be that both firms are, responsible here. It kind of depends on, it's kind of up to them to tell you otherwise. So I don't think it automatically ends the inquiry. I've been involved in some cases where the sexual harassment and the matters that I'm thinking of were actually actions taken by a third party who was known to be a problem by the employer, business owner. So I don't think it's automatically closed down by that. And I guess the thing that I'm wanting to know a little more about on the second issue, and I get it, and I thought you explained it really well, Commissioner Mobley. There are these two rules that aren't really rules. And then there's the third item, which is, she's pitching a fit because she doesn't want a particular numbered badge. I kind of feel like those are two separate things. Either a rule is a rule, or it's not a rule. And so I'm not very persuaded by them saying, well, she took the masks and the treats that are really not for other people. The third item I think is more interesting. If her response was disruptive, or if this resulted in delay in her being on the clock or doing the job that she's engaged to do, different thing. Did you feel like those two rules about the vending machine and the masks for visitors, did you feel that that was kind of a reach on the part of the employer?
Well, if I can add just a little bit of color to the situation. I do believe, based on speaking with a former employee of the janitorial service company and speaking with the complainant, I do believe that the work environment was hostile because the security team openly, blatantly made comments in regards to her physique and how she's more of a masculine build for a woman. And they openly created that environment. And in putting all of the pieces of the story together, it was a thing where it's something that kind of everyone did loosely, but no one, and then they brought it to the attention of the client. And then the client complained to the company. And when the client complains to the company, that's when termination happens, or change in location for the employee happens. And what I found is that there was some breakdown in HR policy for the company in which the complainant worked. And she never lodged a formal complaint with her company nor Medjit. So there was no formal investigation launched.
Did they have a published policy? Did she have an employee handbook that would tell her how to go about making such a complaint, or did they even have that?
They do have a handbook, and it's one of those things where as you are moving through the hiring paperwork, they say, hey, here's a handbook, sign off that you received it, and you sign it and never really read full detail to understand how that works. So with her being the only female employee and all of her superior employees, her team was comprised of 2 floor bosses and 3 team members. The floor bosses were white, the security members were white, her and the other 2 team members were Black. and she is older than all of them. So she felt as if all of these things played a factor in the kind of the chatter in the workplace. And then with that being said, she did not necessarily respond in the way that would be the corporate ruling, the HR policy way to respond to that. She did not respond in that way. She had a more emotional response to it.
Commissioner Mobley, I have a question.
Sure.
If the, and just to the point about the employee handbook, there are so many things, you know, the employee, my experience, employee handbooks, they cover general principles and they probably don't get down into the weeds about, you know, who takes a mask and who eats the snacks. But my question would be, you know, a lot of that stuff is nuanced in a different, in, you know, various work environments. So even if it's an unspoken rule, where did the complainant feel that, well, if other people say forget their mask, they grab one, nothing is said, but I grab one, then there's a big to-doodle. Or other people grab chips, but if I grab chips. So what was it, did you find that it was any of that? Could you detect whether there was, did she at all say that other people from time to time took a mask or took a snack and there wasn't anything said?
It was that way with the snacks, not necessarily the masks, and it was in excess. So when I asked her specifically about the snacks, she said she'd bring her own lunch, but she might take the snacks twice a shift. And then the masks she took every day. So, and while yes, there were other people who took snacks as well, I'm not aware of how often others took snacks.
Okay. I'm going to have to walk out soon, but if there was anything in her understanding that said the masks are for the guests in the building or others, and the employee or contractee is expected to furnish their own mask and not help themselves to a fresh mask every day. And if there is some understood statement that, well, those snacks in that dish over there, that's for the guests, or the guest, you know, the people who come to the company to do business. That's not for the employee or staff or quasi staff to take part in. And if she knew that, again, if it was, whether it's in a handbook or not, if that's kind of an understanding, and again, then your word excess kind of plays a part as well. I'm sure maybe if it was one mask, once, maybe twice, you know, the snack thing, maybe, you know, somebody takes chips once, they didn't get supper or they're feeling lightheaded. But I guess the word that you threw in, excess, kind of makes me wonder to what degree it would raise a flag if people wanted to use it to raise a flag, I guess.
And that's a great question, Gina K. In her mind, the masks were a necessary thing for her because she has asthma and she's cleaning and COVID prevention, that kind of thing. So in her mind, it was a perfectly acceptable thing to take a new mask every day. And it wasn't until it was brought to her attention, which it was, passed away, that she wasn't supposed to have it every day. Or she wasn't supposed to take the mask for the guests every day.
Okay.
Commissioner Thomas, you look like you have a question.
I did. Greetings, everyone. I think the question might have, my question was, a policy that's understood sometimes is very subjective, who understands what. So the absence of an explicit rule that's written or communicated by policy or email is troublesome to me and not determinative of whether this matter should be dismissed. No, I mean, you know, so the other piece that I'm thinking about is, Okay, so was it brought to her attention, and how? Because without a written document or policy, people don't know what's a terminable defense, a terminable offense, which is, you take 2 snacks, you take 5 snacks, you're gonna get fired. Hey, we now understand the policy. So I'm just sort of seeking clarification on the extent to which she understood the policy and what she understood the infractions for those policies were, because something that's clearly understood is not always understood unless it's presented in the form of a policy. So if you've addressed that, my apologies, but if you could respond, I'd appreciate that, Commissioner Mobley.
And can I jump in before you respond? Can I ask as you respond, because the application rights, Commissioner Thomas, of that itself can then be discriminatory when you apply and when you don't.
Yes,
so if you could
that's
address
correct.
that, I mean.
Which I would agree with, but we would have to add an additional respondent to the complaint, because the complaint is not against her company. So yes, Nanette, you're right, or Commissioner Pitt, you're right, but that's where it gets a little different here. So there are different levels of things that could look like acts of discrimination for each of the entities involved. To your point, Commissioner Thomas, I'm trying to think of the most gentle way to say it. Sometimes, let me choose my words. This, in some instances, the interpretation of verbal rules can be different. Commissioner Pitt and I can hear the same rule 2 different ways. And I don't think that there was any written documentation in terms of what not to do at a particular client's office as you're cleaning it. And I think when a verbal warning came about, it was in a hostile way. She'd mentioned that her supervisors, who she'd worked well with on a regular basis, were on vacation, and they had new floor bosses in that week, and they noticed the pattern of behavior and brought it to her attention.
Okay, so she didn't dispute that it was a problem brought to her attention, and she recognized it as a legitimate problem.
Right, she didn't dispute that. What she disputed was how it was brought to her attention.
Interesting. So my question previously about the handbook, did you have a chance to ask the complainant why she didn't complain about the hostile treatment, the harassment by the security guys? Did she say why she didn't tell her employer?
She said that everyone knew, those were her words, everyone knew what was being said about her and no one did anything. And I don't know that based on the way she processes things, that she would have had a mind to go beyond her floor boss and speak to HR.
But she did tell her floor boss, right?
Her floor boss was aware, yes. And her floor boss did not then go beyond that and file a complaint with HR or the company at all either. And that person, her floor boss at the time, is also no longer with the company.
Really?
Mm-hmm.
Same time frame for termination or non-retention?
About a month later.
Wow. Well, that
I know.
that sounds fishy. So here's the thing. If she told her supervisor then she carried out her obligation the way, as the law sees the reporting of offensive, unwelcome, severe, pervasive, negative treatment. So she met her responsibility in telling her floor boss. And what's interesting to me is that now the floor boss isn't there. Wonder if the floor boss reported it up and the decision was made that both of them should go. It's hard to say. Are we at the stage where the company has explained all of this away in terms of, oh, we have a policy and, we enforce that policy and so forth?
Well, it's interesting. Apparently, the company has a high turnover rate, and the HR person who was in place at the time is also no longer with the company.
Well, no.
So then it's
We
hard
have a
to,
new HR rep who is still, she looked into the matter, and because in the complaint, in the actual complaint, the complainant mentions that she's looking for compensation. And in our first interview, she mentioned that she was asked verbally not to return to the client site, but her termination wasn't dated until maybe 3 weeks after that. And she said that it affected her unemployment benefits because of the way that it was done. However, when you speak to HR now, their date of termination matches the date that she was told not to report back to work, which is the date that is on her complaint.
And is she getting her unemployment now? Do you know?
I do not know if she's getting unemployment now. I do know that there was a delay in her receiving any benefits whatsoever because.
Well, Commissioner Mobley, I'm wondering if what they claimed was that she abandoned the job. No.
Their records only indicate that she is inactive.
Wow. So I know this will surprise everybody, but I'm not ready to say that this one should be dismissed. But it's complicated. I agree.
And again, I'm sorry to interrupt, but and again, her employer is not the respondent. It's not who she has the complaint against.
But her employer does have a legal obligation to address hostility or harassment in the workplace that they've been made aware of. And I wonder if we've got a friendly person in the floor boss who's now no longer with the company. Is this somebody, I wonder if this is somebody we could reach out to.
I spoke with not the direct floor boss, but the assistant. So one of the others, so she listed two, and I spoke with one of the two, and their response was, and this is a direct quote, "I believe she has mental health issues." And that's all I'm willing to say.
The complainant, that is.
Yes, speaking about the complainant, they said, "I believe she has mental health issues, and that's all I'm willing to say at this time, and I'm no longer with the company." So neither of the two are with the company.
Wow.
so let me just review kind of where we are. The report comes back and then we make although I think this is, and by way of clarification, right? I don't hear that you're necessarily making a recommendation one way or the other, but our determination to make is kind of a preliminary, if there's reasonable cause to believe, right? This is not a final finding. This is just right? Do we think that there's enough here for a reasonable person to think that discrimination happened? Because if we make that determination, then we go into the what's the word? The conciliation process, right? Where a different commissioner, right, would contact the respondent and the complainant and see if they can work something out. And it's not until after that, if there's no conciliation, that we would actually hold a hearing and actually to get evidence presented. and sort of make an ultimate finding. I'm not saying that to rush us along towards a decision or anything. John, do you have any thoughts on where we are procedurally, sort of what we might do? I think that it would be within bounds to, if there are specific questions that would help us clear things up, to ask the commissioner who was assigned to do the investigation to go back and find out, try to answer other questions that are still outstanding for us to make this determination. Or, I don't know at what point whether we just need to take a vote based on what we know.
Well, if I could give my recommendation, I don't mind.
I'm sorry, say that again.
I said, I don't mind giving my recommendation because I had one, just I didn't know exactly if this was an okay recommendation. Because while I do believe that there was harassment amongst the employees and discrimination amongst the employees, I think that moreover, there were some missteps in HR procedure. And I think that is the part that stands out the most. So I didn't know if the recommendation could be that the respondent is changed.
That's sort of
I
what I
see.
was getting at. The thing that I think is hard to predict is whether it was the contracting company, right, or her direct employer that made the decision about her not coming back there.
It was
What about adding a respondent? Procedurally, can we add somebody? I'm sort of hesitant to say, yeah, good idea to let the current respondent go, because I don't think that's necessarily.
Actually, could we get clarification on who we think did the termination? I just wasn't quite who's initiated the, did somebody say don't send her back again, or did or did the employer say, oh no, we can't have her there?
the client requested that
Client requested.
that the contracting company not send her back to that site.
And the client is also the discriminating party?
No. See, so
yeah, no, I don't.
There are two.
Oh, I see. The other
companies.
contractor. Yeah.
There's two contracted companies working for the same client. The first contractor is the complainant, the second contractor is the respondent, and then there's the client.
Okay.
Second contractor planted the seed regarding activities of the first contractor with the client, and then the client in turn requested that she not come back.
And then the contractor one for whom she was employed then made that a termination. Not only did she not go back to that client, but they terminated.
Yes.
Well, I might be, commissioners, I might be looking, I know I'm looking at an earlier version of the roles of the organization, but formally section O under complaint and answer does provide that prior to, a complaint may be amended at any time prior to a hearing on the complaint or an order by the commission dismissing the complaint. So being able to, so certainly the complainant would have to make an amendment in writing, sworn and signed and filed in person or by mail with the City of Akron Law Department Civil Division. And so the commission shall ensure that the respondent is noticed with a copy of any amendment. So to your question, Attorney Holland or Commissioner Holland, yeah, the rules do provide for that. Although I am looking at an earlier version, I can't quite find my recent ones. The complaint can be amended.
I think that's currently in Rule 15D of the rules that were adopted on March 3rd.
Okay. Okay, all righty.
Mr. Chairman, to answer your question about procedurally where we're at now. Rule 16G includes this sentence. Upon receiving such a report, meaning a report from the investigator, the commission shall either make a finding as to reasonable cause or direct the investigator to continue their investigation upon a vote by the members. So I think there will either be you'll either get to the decision on reasonable cause, or you will have the investigator continue based on what you've heard tonight. And part of that may be, seeking to have the complainant amend the complaint to include this other company.
Got it.
That would possibly open the door to further investigation, but be able to dig a little bit deeper.
So is it time for a motion?
Sure.
Okay, I would move that the commission recommend continuing the investigation of this matter to include further interview with the complainants. There it is.
Are we going to include something about requesting that the complainant consider, is it something we request of them to change the respondents, or do we change who the?
I think she has to be interviewed again first. I don't think we can put those words in her mouth
Right.
in the form of a motion now.
So I'm just trying to sort out, actually, can we have is there a second on the motion, and then we?
Commissioner Thomas seconds.
Fabulous.
Please.
And so now we can discuss. And I'm, so, we can of course initiate. I'm trying to figure out how that mixes in here. We can also initiate complaints on our own behalf if we think discrimination happens. So it's a sort of another way to say, if we've identified discrimination, even if it's not the party identified by the complainant, right, we could file a complaint. I do think that since it's all interrelated, we've got sort of something in between here. And I do think, Commissioner Holland, that while it's true we don't want to say as part of the motion, you should amend your complaint and accuse somebody else, right? That defendant would not be very happy about the commission, right, suggesting a complaint against them. I think it's fair to in the discussion with the complainant to identify what we've discovered, that, right, there are actually an entity other than the one she named as a respondent who is currently not within our jurisdiction because they haven't been named on a complaint, although that the complaint, of course, could be amended. Yes, Commissioner Thomas.
I'm sorry, I keep doing, I'm sorry. I did have a procedural question with regard to joining a party. If the complainant hasn't actually named or didn't the complexity of those relationships, that could the commission sort of sua sponte, join the appropriate party? On one end of the spectrum, the other end is that we, through Commissioner Mobley's diligent work, that we let her know you've named the wrong person and you have X number of time to amend your complaint. I think I'm not sure if we're able to actually join the party, but certainly let her know that there's 3 separate entities here, and here's, in order to proceed further, we might need to have them in the complaint. So, John, is there something about joining of parties by the commissioner or the commission?
The rule that you recited earlier is the only one I see on that. And that to me makes it sound like the complainant does the amendment to the complaint. Because it says any amendment must be in writing and signed and should be filed in person or by mail with the City of Akron Law Department Civil Division. To me, that means, the complainant does the amending. It's not the commission that adds a party.
If I might interject here, my concern with that, while I think it is a great idea and I think it is the right direction, my concern is that the complainant might not be able to fully comprehend this process and what needs to be done without it seeming as if we've coerced her into an activity.
That was my concern. I was
If
going
I
to raise
can
that same question.
add a little color to it, as we all know, this particular complaint was already filed with the Ohio Civil Rights Commission. And I asked about that, and it was an accidental file with the Civil Rights Commission, with the Ohio Civil Rights Commission, as she meant to file with the Akron Civil Rights Commission. So I would have concern with her
Procedural.
being able to follow it procedurally.
So did she say what she did with her complaint that was accidentally filed at the Ohio Civil Rights Commission?
Yes, she said nothing. She said she did nothing because she didn't understand it.
So it's
So
the
do you mean that
process.
she checked the box accidentally? Or that she actually sent something to the Ohio Civil Rights Commission by accident?
She both. So she sent it to the Ohio Civil Rights Commission thinking that she was sending it to the Akron Civil Rights Commission. And there are several boxes checked within the complaint that she didn't fully understand. And she just checked the boxes. So.
John, do you think that we have fairly general powers, I think, to conduct these proceedings? And I'm wondering whether, even if it doesn't say anything specifically about joining a party in our rules, whether, as part of our sort of inherent authority, whether we might be able to do that. I know that's a little bit of a harder legal question than what than
To offer, sorry, Chair, that didn't mean, but to
please.
offer support for that, with a prospect that, yeah, this might be a complicated process, but part of it was, it's supposed to be pro se. I mean, people are, and typically with pro se litigants, while we can't, in other in other court situations, they have to be treated in a way that a lawyer wouldn't be, or a professional wouldn't be, so that they do have understanding of that process. So I understand the fear that she may not the individual might not understand, but that's okay. We understand. And, we have, certain authority to be able to create that understanding of the process, or to identify the next steps. Whether or not she complies with that is certainly on her. With regard to the accidental filing, if she accidentally filed it, then we would wait. I think that should not determine what we do necessarily, because the Ohio Civil Rights Commission can dismiss it.
That's right.
Or she can withdraw.
And Bradley Dunn already made it clear too that that's a separate process unto itself. It does not touch us or concern us in any way. So I think we just disregard the Ohio Civil Rights Commission matter. The only thing that would make me change my mind is if there were a substantive determination by OCRC that this complaint was meritless, which I envision this coming up somewhere in the future, where we have to decide if we are going to, treat another agency's determination as dispositive. It's sort of the flip side of the question that we asked of the Ohio Civil Rights Commission, right? So I agree with Esther, in as much as this commission and its process, I believe, was set up so that one does not need to have a lawyer to navigate the process. That, one should be able to handily navigate this. And it's true that not all complainants will have the same capacity to understand or articulate exactly what has happened. But again, that's where we come in, right? That's up to us, which is not to say that we're here to help one party to the exclusion of the other, but rather we're here to drive this in a way that leads to truth and some fairness.
So
Commissioner
along
Pitt.
those lines, I feel what I'm hearing is that it sounds sticky for me for us to send Commissioner Mobley back to, it doesn't feel transparent to me for her to go back with the agenda of trying to get, well, not necessarily even if she was trying to get the complainant to put the other company onto the complaint. I feel like the most transparent thing is for us to take on that role as the commission to say this is within our
purview, yes,
to undertake, and this sees to the needs of the client, and for us to do that transparently rather than trying to offer counsel or to be perceived as offering counsel to the complainant. I think it's better if we simply make that determination, and then those respondents can object. They can say, this is why I should not be. I think somebody made that point earlier. In fact, Nancy, I think you made it right up early in the conversation, to say, this is why I don't believe we should be included in this complaint, and we can then consider that. But I feel it feels more open to my mind, and transparent.
I agree.
Are we talking about both of the other parties, the client and the actual employer, right?
The respondent said that had they been made aware of the complaint, that their zero tolerance policy would have kicked in and they would have moved forward with their own investigation. That was their response.
That was the respondent that said that?
Mm-hmm.
Okay.
The respondent said they were not made aware until the complaint was filed that this activity was happening on site.
I may be getting confused at this point, but can you clarify, didn't we have the conversation about the fact that the floor manager was made aware?
If I can use company names, the floor manager is employed by JSI. The security guards who used the harassing language, or who were allegedly using harassing language, are employed by contracted through Medjit.
And it's
And-
Medjit who's named as the respondent in this
And it's-
complaint.
And it's
And then-
Medjit. Go for it.
And then so then I don't see that as a reason to make a determination at this point. I would want to know as a commissioner, then if we add Medjit to the complaint, did Medjit have, because earlier on you said that everyone knew. So then did Medjit have management on the floor, and were those people aware? Is then for me a follow-up question. Because
That's
to
a good
simply say, if we had known, well, that's not necessarily determining for me. I want to know, did you know?
Right. Or should you have known? Yeah.
Or should you, yeah, you can say, oh, I didn't know, but because if the complainant is saying everyone knew, then there is a possibility of discrimination there.
So if I'm understanding correctly, Commissioner Mobley, I think that you fairly clearly said that you thought that discrimination happened or that harassing conduct occurred. It's just a little bit of a question on who exactly is responsible. And if we're now talking about joining the other two parties, then, you know, at that point, it sounds like we're prepared. You would recommend that there is probable cause or reasonable cause. Sorry. Am I understanding that correctly?
Yes, I think.
And the motion is to instruct the investigator to continue the investigation, to include a discussion with the complainant at least. And I don't know, and that's the extent of the motion at this point, right?
Right.
So I'm wondering whether we want to amend that motion to be in some way more definitive about the other two parties.
Yeah, I think I'm going to withdraw my previous motion. And instead would propose that the motion be that JSI and I'm sorry, what was the name of the other?
Medjit,
Pardon me?
Medjit,
And Medjit be named as additional respondents in this complaint number
3 and
20
4.
ACRC 00003 and 4.
So, and who's the client? Wait, Medjit is the security
Yes.
contractor, right?
Well, no, Medjit is
No.
the company that hired the company that provides security.
Oh. Who's the security company?
They said that they provided that in a letter to Phil, but I don't have the additional portion of that letter. They said that they provided a copy of their HR zero tolerance policy and the name of the contractor. But I don't have that. I was going to ask Phil about that.
I believe Medjit is already a respondent. They're the original
They
party
are.
the complainant complained about.
Mm-hmm. They are, and they have been, they have responded to me openly. I've spoken with their director of HR. They also sent a letter saying that because the security guards who are accused of the discriminatory or harassing language did not work for them directly, nor did the complainant work for them directly, that they don't know what to, they don't have a response, that they don't feel responsible. Which,
And Matthew Spellman, who's named on 04, is that the actual security guard?
no, Matthew Spellman was Matt was the assistant floor supervisor. He is employed by JSI along with Mark, who is
Okay.
they are both the people who she looked to for guidance.
So JSI is already in here, their employees were named.
Their employees were named, yes, but their employees were named as more of witnesses versus respondents.
So then when we send a notice to the respondent, that was sent to Megat again. Okay, Megat.
Because in both complaints, in 3 and 04, Megit is named as the respondent.
So what we need to do is vote on whether we agree to amend the referenced complaint to include JSI, correct?
I thought the rules said that we can't amend. We can have a new.
The rule's silent on it.
Oh.
Yeah, that was the conversation, was that we felt we should. Because the rules allow for us to undertake investigations.
Right.
I think that there is credence for us to, if we can initiate investigations, then I think it allows for the fact that we can amend in this instance in particular.
I
I
agree.
think we say that we're pursuant to our authority to initiate a complaint. We're adding parties to this complaint.
I'm much more comfortable with that.
Right, and I agree with what the chair said and Commissioner Mobley, because without this action, we can't really pursue our charter because we are not looking at the right parties. So it facilitates our ability to affect the business of the commission.
I guess one of my outstanding questions is whether, do we need to know the name of the security company contractor and include them?
I think that you can properly go forward without them as a party or identified for the role that they played, because what we're really talking about is an alteration of the terms and conditions of the complainant's employment.
Right.
Right?
Right. Yeah.
Unless Commissioner Mobley has been advised by the complainant that in addition to the verbal harassment, that there was, there were the elements of, criminal assault, touching, of a sexual kind, let's say. Okay, that would be a slightly different animal. But I didn't hear anything like that. Am I right, Commissioner Mobley?
Yes, there's no accusation.
No allegation of that. Okay. So I don't think it's necessary, but
No, I hear you. I think that the guard will be, the guard's conduct is key information, but they're not the ones who either fired her or terminated her or took her off the job.
no.
It's Megat and JSI in combination who did that. And those are the consequences that she's complaining of. So I'm sorry, remind me. So the motion was that to
amend,
to add JSI, and also to we're also still asking the investigator, I think, to find more information.
That's correct.
And do we know sort of with any clarity what we want her to find out?
In no particular order, I think we'd like her to speak with the floor manager who JSI may insist on being involved in that if, as we think, he really was a supervisor, right? So that would mean that the JSI might want to be on that phone call, and or the JSI is obligated to produce the guy for an interview. I mean, it cuts both ways. So I think we want a conversation with the floor manager to ask him, did she report to you that this was happening? Did you observe this? As the supervisor, did you make your subordinates aware that there's a policy against harassment and that there's a procedure for reporting it and getting redress of it, etc.? I'm real interested in that floor supervisor.
Well, and once JSI is noticed, right, then the interview with the former floor manager it's a different stance. They're now employees of the respondent, right? Because you can ask JSI for answers to those questions.
Yep.
Nanette, are you waiting to speak?
No,
I thought okay.
no, I was meant, Commissioner Holland just covered exactly what I was going to say, which was the
Okay.
question earlier about the supervisor and knowing.
Commissioner Mobley, is that motion clear enough to you, since you're going to be the one who has to follow up on it?
I'm unclear on if we are amending the complaint, or if we are pursuing something on our own as the commission with a
I would say it's both, that we are amending it pursuant to our authority to direct or initiate an investigation.
Okay, I'm comfortable with that.
And Commissioner Mobley, I'd like to just kind of put my money where my mouth is too. And I think this is a slightly complex procedural thing. And if I can help, be in touch,
Yes, please.
Yeah, as you're dealing with this. Yeah.
John, I'm thinking about what we, actually, maybe should we vote on this motion? Let's do that.
And are we assuming that Commissioner Thomas's second still stands with the amendment?
Oh, good.
I renew my second of the revised motion. Thank you.
Fabulous. Any further discussion? And then, I think I'm going to ask John next about sort of what we might need to do formally to carry this out. So if there's not discussion, let's all in favor say aye.
Aye.
Aye. All right, the motion carries. Oh, any opposed? The motion carries. And we don't have to leap into action this moment. I do think that one of the consequences is going to be that the respondent gets a notice, right, the way the respondent usually does. And Commissioner Mobley, you can wait for that notice to be sent, I think, before then contacting JSI to sort of continue the investigation. I just don't know if there's I don't know if we need to produce a new document that names JSI as a respondent, or if the minutes of this meeting will be, enough of a record to say that we did that. But we can think about that. We don't have to decide this minute, I think, exactly how to carry that out.
Yeah, what I anticipate doing is preparing a letter to JSI to inform them of what transpired at this evening's meeting and providing them copies of the 2 complaints that were filed.
Okay.
And Latanda, I'm going to need to get some more information from you. It doesn't have to be now. It could be by email or something about JSI, address, or contact information if you have any of that.
I wrote per the rules, I wrote up the official investigative plan. And I don't know who that goes to.
That's really for your own use to help you with the investigation. But I'd be happy to take a look at it. Whereas the other members, they need to sort of stay somewhat distant from the investigation, because ultimately they could end up hearing about this. You know, but if you'd like me to look at it and maybe help you in some way with the investigation, I'd be happy to.
Yes, please again.
All right. Ellen, did you have something to add?
Sorry, like a lot of things going on over here. Yeah, I just wanted to follow up and make sure that we were being cognizant that anyone who's involved in the investigation then can't sit on any hearing that may occur. So I know there was an offer made for assistance, but just wanted to remind everyone how that works, and that Latanda is the only person who's been assigned to do the investigation. So she would at this point be the only person who had that conflict. So just flagging that issue. That's all.
Thank you for that, Ellen. And I'm sorry, recognized by the chair. I just want to clarify my understanding. Then, John, you just offered your assistance to Commissioner Mobley with regard to the procedural steps. Is that a correct understanding?
Yes.
Good. Good. I
Yes.
just want to make sure that we're covered. And I'm going to, I guess, for what it's worth, officially withdraw my offer of assistance so that we don't encumber too many commissioners.
Right.
Thank you.
All right. I think that resolves that complaint, that item on the agenda for now. We turn to new business, and I'm cognizant of the time. I don't think that we received any new complaints. You may have seen some of the email with regard to the proposed Crown legislation that amends our the ordinance that we operate under. And I think that you were circulated the draft draft language. My understanding is that that's going to be heard by City Council next Monday. I had inquired about addressing them. I am personally in support of that. I think one of the things that I think that we ought to chime in anytime there's a proposed amendment to our ordinance. I feel a little bit of ownership over it. But whether that were true or not, I'm in support of this particular amendment, and so would have spoken up in support regardless. But I think for us as a body, the question is whether we want to endorse it sort of as the Civil Rights Commission, and we'll just open that for discussion. Or I don't know if we should have a motion, I suppose.
I didn't reply to the emails, but Mr. Chairperson, I would gladly make a motion that we officially, as the Akron Civil Rights Commission, support the passage of that legislation.
I enthusiastically second.
So then discussion. Which I think is not necessary. So we could pass that and then talk about what happens sort of procedurally, I think. If there's not discussion on the merits, then we can vote. So all in favor of endorsing the proposed Crown legislation, say aye.
Aye.
Aye. Any opposed? So that That passes. It is endorsed. Um, I think that there is a Rules Committee hearing on to discuss this next Monday. That I have because of my inquiries have already been invited to attend, and then it'll be heard at the full council meeting. Ellen, how do we want to go about this? Do you have suggestions for what we do sort of logistically? Should we draft a statement? Should we, I mean,
I think you guys can do whatever. There's really not a lot of precedent for that. You could certainly just come on behalf of the commission and, indicate the favorable vote and, maybe expound a little bit more on, your support, or certainly a letter could be drafted. That might take, again, if you guys wanted to approve it over email, that might take a little bit more time. Monday is just a couple days away. So yeah, I think honestly, just coming and verbally expressing support would be perfect.
Would it be appropriate if other commissioners wanted to chime in or appear?
I don't see why not. I was at the commission meeting or the committee meeting last week, and I think they just wanted to hear from the commission. So I think you were selected as chair more than anything. So I'm certain that they would be welcome to having multiple representatives come. It's all on Zoom. We would just need to arrange to have your name shared with the council clerk so they can give you the login information. But I don't think that would be a problem. And then while I'm not sure it will go to a vote on Monday, just based on some of the questions that I heard from the committee members, it might, certainly could, but they might take another week's time just to, continue deliberating on it. So.
And is there any point in submitting?
It might go to the 7 p.m. meeting. It's hard to predict.
Is there any point in submitting public comment in addition to sort of expressing verbal support?
Yeah, so that's the best, and right now the only way to participate in the 7 p.m. meeting, as far as I know. So they're not really having outside guest speakers at their evening meeting, just because it's a larger meeting and like from Zoom perspective. So that would definitely put you on the record, and if they would vote before the public comments. So if they vote in favor of it, then your comments would come after, but it still makes it part of the public record, the official record. And if they don't vote on it, then certainly it would get before all of council that way. So, because not all of council goes to each committee meeting. So you might only be speaking to the committee members in the afternoon. So also you can submit those in writing right now. There's two options. You can send an email and then the clerk will read them, or you can do a voicemail. So if, even as individual members, if you'd like to type something up, or if you'd like to submit something as a group, you can do that in writing, which is easier than not. So
Maybe you could record a video message. Can we do that?
No, I don't think they have the tech. Nina's on there. She could tell us, but I don't think they can.
Somebody could share it by, on Zoom.
You might make Sarah's head explode if you tried to do that one.
Yeah, it's been enough to get the voicemail option for baby steps. And hi, John, welcome back. I was worried you weren't coming back, and I was
Sorry.
job of speaking.
I just got cut off. I'm not sure why.
I don't think we got into any trouble while you were gone.
Okay.
Perfectly legal.
I dropped off just as we were starting to talk about council. So I don't.
So we were
think
just
need to
discussing
relive
different
the
ways
whole thing.
they could participate or express an opinion on Monday.
Mm-hmm. Did it sound to you, Ellen, like they also wanted like the commission's report about business at the committee meeting?
The report about business? What do you mean?
Yeah, like they do the
semi-annual report?
The semi-annual report.
We could certainly have the last one available. Did they Did we miss a deadline?
We might have.
Brant is not hiding his feelings very well.
Yeah, don't ever play poker with me.
Yeah. No, we should play poker with you. You would be the best opponent.
I think that those were in April and October, and I think that we missed an October semi-annual report deadline. So that might be something we can at this point present it on Monday, since we won't have adopted it. Well, unless I guess.
Although you could agree to just send them the meeting minutes from all the meetings between April and October, and have that serve as a report.
Right, we've done that before with kind of a cover letter.
Yeah. Could do that now.
Yeah, and then you could just give an overview sort of what you've done.
I think in the past we've tried to summarize sort of numerically the number of complaints. Although activity has been slow this year because of everything. All right. Well, if we pull that together, I will circulate it by email, and whether we approve it by email or present it as to be approved, at our next meeting. In some way, we could offer that as well. Any other questions or comments about the Crown legislation, or actually, I'm now going to wrap up, or any of the other community involvement issues that we have discussed in the past. I will let you know that I am staying in contact with the Commission on, what's the name of it, Racial Equity and Social Justice, and also with the public safety groups, deliberations about potential recommendations for police reform. And I know that I mentioned at the last meeting that we remain open as a body to any activities we might undertake in sort of an educational way. And I am just in full disclosure, I'm kind of considering whether I, either in my university capacity or in some way in this capacity, want to sort of jump into that process, because I gather that there is some need for motivating energy. I don't know if that's quite the right word. That there might be some call for involvement in that process to help it move forward productively. There's nothing to report. There's no proposal. I'm just letting you know in case something comes up that I may bring up at our next meeting. I just think that whole bundle of issues that is being considered is something that it would be well within our purview to want to be involved with in some way, and that they may need our whatever capacity we have, even if it's not necessarily that much. So I just wanted to share that much with you. Any other thoughts or reports? Did we receive any public comments? Oh, Commissioner Pitt.
Sorry, I had spoken before about an event with Black Lives Matter to raise that. So I'm still working with you, Francia Lash, in planning that. and would still love for you all to be involved, but we decided we needed to put that off till the new year, just based on what was happening in the city and holidays. And I think everyone's feeling a little COVID fatigue. And so we had determined that, and I had meant to send you all an email to update you, and I apologize for not doing that. But there we go, there's the update. So you will be hearing from one of the two of us about that.
And I did check on the public comments from the November 6th meeting until today, and there were no public comments received.
Fabulous. And I guess that takes us to the end of our agenda. If there's nothing else, then we'll entertain a motion to adjourn.
So moved.
Is there a second?
Second,
There's a
Nancy.
second. All in favor, say aye.
Aye.
We are